Greetings, Left of Awesome. I'm Quantum Tuba, filling in for Nick this Wednesday, and the Ninth Circuit U.S. Court of Appeals has thankfully rejected the shameful use of the state secrets privilege by both the Obama and Bush administration. What the Obama administration was trying to do in this specific case, and they were doing it as a direct continuation of Bush administration policy, was to say that if they deem certain evidence to be classified and subject to state secrets privilege, that is something too sensitive for them to release to the public, then they can remove the case from going under any judicial review. Effectively, this would destroy checks and balances because the executive branch would be given unconditional power to remove all judicial checks upon them. Since most CIA business is secret, the CIA would become even more immune from constitutional law than they already are. It would help develop a stronger executive branch, just as tons of Bush administration decisions already have, and it would be disastrous for civil liberties and for checks and balances, which is why this decision was excellent. I'm going to quote from the court's decision right now. They say, "At base, the government argues here that state secrets form the subject matter of a lawsuit and therefore require dismissal any time a complaint contains allegations, the truth or falsity of which has been classified as secret by a government official. The district court agreed, dismissing the case exclusively because it involves allegations about secret conduct by the CIA. This sweeping characterization of the very subject matter bar has no logical limit. It would apply equally to suits by U.S. citizens, not just foreign nationals, and to secret conduct committed on U.S. soil, not just abroad. According to the government's theory, the judiciary should effectively cordon off all secret government actions from judicial scrutiny, immunizing the CIA and its partners from the demands and limits of the law. The state secrets privilege operates according to no such assumption. In fact, Reynolds makes clear that classified cannot be equated with secret within the meaning of the doctrine. If the simple fact that information is classified were enough to bring evidence containing that information within the scope of the privilege, then the entire state secrets inquiry, from determining which matters are secret to which disclosures pose a threat to national security, would fall exclusively to the executive branch, in plain contravention of the Supreme Court's admonition that judicial control over the evidence in a case cannot be abdicated to the caprice of executive officers without leading to intolerable abuses. A rule that categorically equated classified matters with secret matters would, for example, perversely encourage the president to classify politically embarrassing information simply to place it beyond the reach of judicial process. It follows that, while classification may be a strong indication of secrecy as a practical matter, courts must undertake an independent evaluation of any evidence sought to be excluded to determine whether its contents are secret within the meaning of the privilege. That is a very important and very true statement with which I completely agree, and with which apparently both the Obama and Bush administrations disagree. Now, there's the fact that this could be applied to, be appealed to the United States Supreme Court. Don't go there, Obama. Just don't. If you do, you have a chance of winning, and in doing so, you not only give yourself far more power than you deserve, you give future administrations far more power than they deserve. Destroying checks and balances, even if you think you can trust yourself with that power, you can't necessarily trust the next administration. For instance, I doubt Obama would have been willing to trust Bush, or Bush Sr., or Nixon with the kind of power that he's trying to get in this court case. So if he appeals it to the Supreme Court, he risks giving future Republican administrations that power. I don't trust the Democrats with it either, but I'm sure he wouldn't trust the Republicans with it. It would be a horrible thing. He'd be as guilty as the Bush administration of destroying checks and balances and giving exorbitant power to the executive branch. And that's a bad idea. A very bad idea.